Okay, good morning, everybody. We are now live again. Today, I'm going to be taking you through privacy and privacy compliance. It is the second part of our cloud security and privacy webinar series. As I noted last week, my colleagues are in the YouTube chat. You can leave any comments that you have, any questions that you have concerning this particular topic in the chat. And my colleagues will capture those topics and I'll address them closer to the end of the webinar. I am Lunda Wright. I'm a customer engineer and in charge of the technical account management capability at Open Networks. And I'll be your host for today's webinar. I'm going to briefly go over the webinar agenda. It's a bit of a longer webinar as compared to the security webinar that we went through last week. For those of you who attended the security webinar last week, you'll notice some elements have been repeated, but rest assured that I've changed things up just a bit to keep you interested and keep you engaged for the entire webinar. To start off with, I'm going to tell you a bit about Open Networks, and then I'm going to go over, give you an overview of our security, privacy, and compliance framework. We're going to do a brief recap on the security workshop that we did last week. Then I'm going to launch into the meat of this particular webinar, where I'll be covering privacy and privacy compliance. I'll take a brief moment to talk about our products and also a brief moment to talk about our services and resources. And then at the end, we're going to deal with questions. I'm hoping to make more time available for the question and answer session. So I'll keep everything in this before the question and answer session to a minimum. Open Networks is a company that is headquartered in Bryanston, Johannesburg, and we have satellite offices in Cape Town and Durban. We make cutting-edge collaboration technology accessible to business and education organizations to connect people, to empower creativity and innovation, reshaping the markets we operate in, and we enable our customers to be successful and resilient. We have a number of products within our basket of services, including Google Workspace, Google Cloud Platform, Google Maps Platform, Mondaycom, Contact On, Edu On, Train On, and hardware under Chrome On. I'd like to take a moment here to highlight our professional development specialization. Open Networks has received a specialization from Google for professional development. We're 1 in 50 partners worldwide with this specialization and the only one on the African continent. So you can contact us in order to derive benefit from our professional development division, who work very closely with educational institutions and also work very closely with business in order to empower business to better use Google Cloud. I'd also like to highlight that we have recently become a Mondaycom Gold partner. We have introduced Mondaycom into our basket of products. Mondaycom is a work operating system which connects all the work processes and workflow across your organization. So you can manage things like company strategic objectives, key result areas, project plans, sales pipelines, and also have plenty of automations and integrations that are relevant to your business. We have found that as a collaborative and cloud tool, Mondaycom is easy for the members of your organization to adopt, especially in comparison to other tools that boast similar functionality. You're also welcome to visit our website, and through our website, you can subscribe to our newsletter. And on our website, you'll also find our Learning Center, and our Learning Center will give you access to many of our professional development resources, which you can use in order to take your knowledge of cloud to the next level. We also have extensive presence over social media, including Instagram, Facebook, Twitter, and LinkedIn. Now for some of the more meaty portion of the webinar. Last week, I introduced you to our security, privacy, and compliance framework. What we have done at Open Networks is that we have simplified the need for you to actually wade through the complexity of security, privacy, and compliance. We have created a framework which makes it easier for you as an individual and for your organizations to understand the complexities behind security, behind privacy, and compliance. As I introduced last week, security is more around technology and the technical matters. So that is everything that has to do with encryption, authentication, phishing protection, and more. So when you talk to us and when you talk to people within your organization, when you talk about security, what we're hoping that you will adopt is the understanding that security is more about technical things. When it comes to privacy, our framework encourages you to understand privacy from the position of your legal rights. And when it comes to compliance, it is about governance that applies to your service providers and governance that applies to you and your organization. A quick recap on the security workshop that we did. This recap is important because it leads into what we need to talk about when it comes to privacy and privacy compliance. There are many key takeaways from the workshop last week. The biggest highlights. When it comes to authentication, we highlighted that the most important thing that you need to pay attention with regard to meeting your technical standards necessary for security is that you must use two-step verification or two-factor authentication for all high-risk data sources, accounts, etc., that you have, in your organization and in your life. One of the big things I highlighted there, for instance, is do not just implement two-step verification for your corporate accounts, but also implement two-step verification for your private accounts, because there's no sense in allowing people a backdoor access to your corporate accounts via your personal affairs, because you might have done something like have a recovery email sent to your private email. When it comes to browsing, I advise you to pay attention to using secure sites and to using native applications that are being provided by many of the service providers that provide cloud services. For instance, when it comes to using Gmail, your security for all your mail access is better managed by using gmail.com or using the Gmail app on your phone rather than accessing Gmail via Outlook. Because once you access Gmail via Outlook, there is the risk that third parties may install certain plugins that can sit on Outlook, which your cloud administrators aren't able to regulate, and and secure your Gmail activities. I also highlighted that when it comes to security compliance, that this is mostly being taken care of for you. In particular, I highlighted things like Google Cloud keeps to the highest security standards. Google Cloud also is subjected to regular audits to ensure ISO compliance, SOC compliance, and so much more. But overall, there is no substitute for your intuition. If something doesn't feel right in terms of security, listen to your intuition and ask for help, especially from professional resources like our technical administrators at Open Networks, our account managers, or other people with security expertise. Now I'm going to take a moment to talk about some of the legal rights related to privacy. The most important thing to remember is that everybody, customers and employees included, everybody has a legitimate expectation of privacy. It is our right in law. It is enshrined within our constitution, and it is enshrined in many of the global instruments that affect our day-to-day business. We are all accustomed to hearing in the news about some really massive and data breaches where private information about individuals has been leaked and has been made available to people on the internet. It is a reality that since we are living in a very networked and globalized economy, that this information, once leaked, can actually compromise the success of your business and compromise your peace of mind on a day-to-day basis. When we talk about private information or personal information, we are referring to things that identify your name, your age, your gender, your job, where you live, and so much more. What the law recognizes that this information is private, and organizations that work with private information need to adhere to various privacy standards in order to make sure that your rights and privacy are maintained. When it comes to open networks, we want to give you the assurance that we value your privacy. Privacy is core to our business model. If we were not treating the information that we get from our customers and from other people with the requisite level of privacy, we would not be successful at the business that we do. We use secure technologies, and we do not share information about you or any of your data with third parties. If we ever need to share that information, we would get your consent or only follow instructions given by law enforcement that have gone through the correct judicial processes. So if law enforcement have not gone through the correct judicial processes, we will not share your information. We also spend time internally getting up to date on security and privacy. And we have senior staff who are responsible for information security, security architecture, and privacy. So we take privacy very, very seriously. So do our partners, including our main partner, Google Cloud. With Google Cloud, you can be assured that your privacy is kept intact. An example of this is that if you contact our technical account managers and you're trying to get information on another one of our customers, we cannot get that information via Google. Google even protects us as partners, protects your information from us as partners. So I want to give you the assurance that when you're dealing with Google Cloud and Google Cloud products, the product is suitable for day-to-day business and day-to-day business privacy. The approach that Google has taken is that with 2.6 billion users on its various services, it has built privacy and security at its core. In particular, and this information is available online, Google is proud to demonstrate that in terms of security and keeping your information private, there are 6 layers of security around Google data centers. This means that even the engineers who work to create Google services cannot go into your private data and glean information about you or about your business. An important thing that I would like to highlight when it comes to Google Cloud respecting your privacy is that Google is rolling out federated learning, which will apply to any of the features and functionality where artificial intelligence and machine learning is baked into Google's products. So, for instance, you'll notice things in Gmail or in Google Docs or in Google Sheets or in Google Drive, where there is artificial intelligence assisting you in completing phrases, in suggesting what you should type next, etc. You can be assured that those suggestions are the product of a privacy model. That means that you're not leaking information about how you work or proprietary information about your business to other customers that are also using Google Cloud. The way Google maintains this is through a novel process that it calls federated learning, where it gathers information, concerning your day-to-day use, anonymizes it and aggregates it, and then sends those results back to your computer or your mobile phone. I'd also like to highlight at this stage that when you use a product like Google Workspace, you can use Google Workspace to help you achieve whatever privacy responsibilities you have. Google has baked into Google Workspace a lot of functionality to help you achieve the requisite privacy standards. In particular, you will notice that most of Google products have search functionality. While the very basic tool in your entire toolkit, search functionality will allow you to do basic searches so that you can uncover information that is probably not well secured. We have used this kind of functionality within open networks to find information that is improperly exposed within open networks itself. I'll highlight a few of the other functions and functionality that is available within Google Workspace in order to assure your privacy. There are calendar controls, within Google Calendar that allow you to manage privacy. This is so that you can, for instance, as an HR capability, make sure that if you're doing things like having sensitive meetings, then you can make the meetings private so that they're not visible, so that the detail of those meetings are not visible to people across your organization. Functionality that exists with every Google Workspace license is email data loss prevention. This means that you can request your system administrators to put in certain rules to make sure that certain information is not shared via email. You can do things like create trusted domains where you can have dedicated easy links between yourself and other organizations, and so that you can make the transmission of information rather seamless, but to the exclusion of other domains, so that your employees cannot share private information with domains that do not have the proper authority to do so. For customers on the business and enterprise SKUs, you can leverage Cloud Search. Cloud Search will perform a holistic search of data across all of your workspace assets. And if you're on an enterprise license, you can also include third-party sources to further enhance your ability to find information within your organization. The Rolls-Royce product that Google provides concerning your privacy is data loss prevention, which is available on your enterprise SKUs. This means that if there's any data in Google Drive, you can configure data loss prevention in order to monitor and prevent the leaking of not only private information, but important intellectual property. I've included here on the right-hand side a screenshot of some of the data protection insights that Google Workspace can actually give you for data that is stored in Drive. In this particular example, it actually highlights that For this organization, there are 13 documents that share sensitive data externally. This is pretty good. With the enterprise SKU, you can leverage data loss prevention in order to actually identify what this data is and lock it down appropriately. Now I'm going to step into the rather vast domain of privacy compliance. Privacy compliance is a very large topic, and I highlight here in the next few slides the key items that you need to pay attention to, when it comes to privacy compliance. Historically, the term compliance has represented full compliance regardless of cost. What this means is that for organizations, if you spend the time complying with particular compliance regulations, you often didn't see the business benefit. This has begun to change in the world of privacy compliance. Within the world of privacy compliance, the regulators have adopted a framework which essentially allows you to adopt a risk-based approach when it comes to privacy. This means that you can and you should spend the time necessary to comply with privacy regulations, particularly as time goes by, which I will explain in the next slide. The most important thing about privacy compliance is that you need to be progressive about it. This means you are better off starting with privacy compliance and doing something about it rather than doing nothing at all, or trying to do everything about privacy compliance all at once. There's a rule of thumb here, which is document everything. What this means is that if you're going to adopt a privacy compliance strategy, make sure that you're spending time documenting it. Also allocate senior staff to be senior staff that should get involved in privacy compliance. This is very important because privacy is an important topic for your business. The approach that we've been taking at Open Networks is that we have created a committee of senior staff whose job it is to actually progressively build out our privacy compliance approach. In terms of allocating staff in order to meet your privacy compliance objectives, favor using business staff that are in your business capability of your organization as compared to staff that are in the IT capability of your organization. What this means is the shift in privacy compliance is that privacy compliance is not an IT thing. It is a thing that business needs to be on top of. After you've allocated the staff necessary to build out your compliance, please be sure to listen to their advice. There are key deadlines that you need to pay attention to. The most important one is coming up on the 1st of July, where South African organizations need to actually appoint an information officer. The information officer is going to be the point of contact between yourself and your external parties, like your customers, for all matters related to privacy compliance. You also need to spend the time educating your employees. So draw up a program where you can educate your employees on security and on privacy and what your privacy compliance objectives are. Key item that you need to pay attention to when it comes to privacy compliance is understanding the difference between being a controller and being a processor. In terms of the various regulations related to privacy, controllers bear the biggest burden of compliance. Controllers are the people who essentially acquired the data or acquired the legal obligations around the data. Processors, on the other hand, are the parties that work with the controllers in order to manage the data. So to give you an example, when you register a new Google Workspace account, the information that you provide, such as your name and the names of the people in your organization, the names that you supply to Google and to Open Networks means that we are the controllers of that information. But we have to be sure that we are the ones who have the biggest burden of making sure that that personal information that you give us about who's in your company, who your employees are, we have the biggest burden of making sure that that information is handled in compliant ways. But in the same vein, Google Cloud also plays the role of processor, because in the background, Google Cloud will be using that information to do things like manage the security of your data and giving you access to your data using the private information that you've provided, such as the email account name and the password. Processors need to use secure processes, which is something that Google Cloud and Open Networks is very, very good at. And if there are any questions around the authority to actually work with data, processors will need to be able to defer to the controllers in order to see whether the controllers obtained the data, the personal data that is being processed lawfully. In that regard, there are 6 categories under which a controller can obtain obtain the lawful authority for your data. The first and foremost one is consent. But you'll notice that consent is only 1 in 6, but it is by far the one that people most care about. In order to get the requisite consent from your customers, we advise things like make sure that you have a privacy policy that is accessible, that does not hide consent deep within the legal documentation. The regulators, both the local ones and the ones based in the European Union, will not look favorably on any agreement that obtains consent by hiding it deep within your legal paperwork. The next one is contractual necessity. The easiest example of contractual necessity is when personal information needs to be disclosed in order to fulfill business obligations. And these include things like we need your name in order to sign a contract, like a master services agreement. We need your address. We might even need your identity number. If there are other legal obligations that allow the collection of personal information, these could be legal obligations imposed by governing authorities. So they all say things like for particular transactions, we actually do need to have your private information. There are also separate vital interests which make acquiring and holding personal information that make acquiring and holding personal information lawful. Vital interests will include things like interests that are related to fulfilling employee, day-to-day employee, internal employee regulations. And for instance, if one of your employees is injured at work, you probably need the information on next of kin in order to get a hold of next of kin and advise them that an employee has been injured at work. Sometimes we also need to acquire personal information in the public interest, but you don't need to worry too much about this category unless you're a business that specializes in public interest matters. Lastly, there may be a category of legitimate interests in terms of acquiring data and the personal information related to an individual, and that's typically, when you are contractually associated, with another party, and you need the data in order to protect the interests of your own company. So I highlight these things in order to deal with quite a difficult topic. As you can see, I'm a bit tongue-tied over this. It's that people often ask, is it okay for us to hold on to personal information that we have acquired by one means or another? And the response that I always give to this is that it actually depends. For most situations, you are better off obtaining the consent of the people that you whose personal information you are holding. But in many cases, people will not have a choice because they're obligated to actually give you that information by contractual necessity or other obligations. But whatever the case is, the most important thing is that you only use the data for the purpose that you acquired it. Which means that if you acquire the information only for contractual reasons, do not use that information for non-contractual reasons between yourself and the people that provided you that personal information. If you acquired that information in order to meet employee obligations or obligations you have as an employer to employees, do not use that information for other reasons, like supply that information to a third party so that they can market products to your employees. If you'd like to do something like that, rather first obtain the consent from your employees. The next tough topic that comes up is GDPR versus the protection of personal information. GDPR is regulation that comes out of the European Union, and POPI is the legislation that comes out of South Africa. Often when we're talking about privacy compliance, GDPR and POPI come up. The consensus is that if you focus on GDPR compliance, you end up dealing with POPI compliance. What does that mean? POPI, as legislation implemented in South Africa, is actually based on the principles of GDPR. The European Union has spent a lot of time working on privacy and privacy legislation, and the principles that have been used to draw up POPI have been based on GDPR and related documents. Why GDPR applies to companies and organizations in South Africa? It's pretty simple. What it is that GDPR says that if you're processing any information, any personal information that relates to a citizen of the European Union, then the GDPR applies to you. This means that the GDPR has a very long reach and applies to any organization where, or any transactions where a person from the EU is transacting with your business. This could be something as simple as subscribing to a newsletter, or it could be something more related to regular business, such as subscribing to one of your services. Since the principles of POPI and GDPR are essentially the same, you can rest assured that whether you focus on one or the other in terms of meeting your compliance obligations, then you stand in good stead in terms of compliance. I would like to highlight here that in terms of the long arm of the European Union, the European Union can fine you for up to 20% of turnover for failing to meet privacy compliance obligations. But you do have to remember some of the things that are highlighted in the background. Be progressive about your privacy compliance. Get started, because those things are important in terms of your risk-rated approach to privacy, and very persuasive in terms of how the local regulator and the EU regulator will view any breaches in terms of your privacy. If you have not been documenting everything, if you have not assigned senior staff to be in charge of your privacy policies, etc., then you're more likely to find yourself on the wrong side of privacy compliance or privacy enforcement activity, if ever implemented by either the EU regulator or the local regulator. One of the things we advise our customers to do is that there is a Google Workspace GDPR data processing amendment. We advise you to actually sign that amendment, because what that amendment says is that you agree and you acknowledge that there are GDPR obligations that have been placed on you and your organization, and that Google is committed to following them. If you do not sign the amendment, you find yourself in a very murky legal position. It means that legal experts will use some of the pre-GDPR obligations imposed on that pertain to privacy, on you, which will only increase your costs and your headaches in terms of dealing with any privacy-related matters that apply to your use of Google Workspace and personal information that you're using through Workspace. Okay, so I've been through the very hard part of giving you an overview of privacy compliance. I'm going to take a few minutes just to go through our products and our resources. I touched on this last week and earlier. We do offer a product that deals with two-step verification with change management. The change management component means that we help your organization manage the change and manage the transition into two-step verification in a way that is least disruptive for your organization, making sure that you and your colleagues are aware of the best options for implementing two-step verification within your organization. We have a best practice wide surface checklist that we can use to actually go through your Google Workspace setup to make sure that the technical surface area vulnerable to security compromise, which often leads to compromise of personal information, and to make sure that make you aware of what is risky account usage. Our checklist will allow, our 10-point security checklist will help you achieve better peace of mind. We have a team that's also focused on security incident responses. So if you have had the situation where you think private information has been leaked, please feel free to contact our team. We can also perform custom security audits, which are targeted audits on specific areas of security or privacy that you would like us to look into. And if you'd like us to empower your technical teams, we are also able to do so. One of the main things I need to highlight is that in the coming weeks, we're going to make available a resource which not only will encapsulate the things that we have covered within the webinar, within this webinar and the previous webinar, but it will be a deep dive into our security and privacy framework, and it will allow you to actually keep on top of what you need to know in terms of these topics. On that particular website, we'll also be making available risk assessments that you can run for your organization or as an individual to point you to what areas of risk you face in security or privacy. At this stage, I would like to now begin dealing with questions that people have around privacy and privacy compliance. Just give me a moment while I open the questions. The first set of questions that I'll begin to answer are questions that I promised participants from last week that I would answer. Last week, Shamil asked the question, how can a super administrator check individual drives for POPI compliant documents that should be kept separately? What I explained last week is that there are certain strategies that individuals can take in order to identify these documents for themselves. What I have done this week is highlight to you what those strategies are. That your employees can employ searches using the native search functionalities within the different products within the Google Workspace suite, such as Search in Drive, Search in Gmail, Search in Calendar, etc. But for super administrators, the thing that I highlighted last week is that you are better off if you're on the Google Workspace Enterprise SKUs, you're better off using the Drive data loss prevention tool. It is an enterprise-only feature, and I provided a screenshot of the kind of information or the kind of information that data loss prevention is able to find for you. There are some predefined privacy rules, such as items related to gender, items related to psychiatric information, items related to credit card and financial transactions, items related to a date of birth. Those are some of the predefined rules that drive data loss prevention come with, which would make it easy for you as a super administrator to turn that on. And by turning them on, you can actually prevent the actual sharing of any documents in Drive that contain that information. Or you can turn that into an alert. On top of that, you can define custom rules for POPI-related items that are specific to your business. Last week, Catherine asked the question, are we required to get our customers' consent to data that we currently have? Or is the data null and void? Furthermore, what should we include for our new customers when they're agreeing to the terms and conditions? So last week, I highlighted that I would do a deep dive into this particular question. The key area you need to look at in terms of identifying whether you need consent for the data that you have or not are the areas of lawfulness that I highlighted earlier. But consent is only one of 6 areas that give you a legitimate interest in terms of holding personal data. And what you have to do as an organization is look at the nature of the data and understand, understand which area of lawfulness applies to why you have that data. For things that require your customers' consent, the answer is pretty much if none of the other 5 criteria apply, then you're going to need your customers' consent in order to make controlling or processing that data legitimate. But I'll also highlight here the thing that I said last week, that the overriding principle is that you should only use the data for the purpose it was acquired, and only for the period of time that is legally justifiable. Okay, it seems that when it comes to any of the live questions, there's nothing new that has come in. So I am going to go through some of the pre-prepared questions that we have kept for this particular privacy webinar. One of the pre-prepared questions I have is Google compliant in terms of the POPI Act, specifically regarding the location of data centers and where my data is stored? That is a question that we get from our customers in terms of day-to-day interaction with our customers, and we also get that question from potentially new customers. The answer to that question is yes. Google is compliant with the POPI Act because Google does enforce the right kind of boundaries between with respect to being a controller and being a processor of data. And where relevant, if Google ever needs to supply information to a third party, it will obtain your consent for it. Or if Google ever needs to supply data to an investigative authority, it will only do so within circumstances that within proper judicial process. One general question is, to whom does POPI apply? POPI applies to everybody. Essentially what this means is that everybody needs to ensure that they are handling personal information correctly. But when it comes to organizations, such as businesses, NGOs, etc., you need to make sure that you apply to the parts of POPI that require you to register an information officer with regard with an information officer for your privacy compliance purposes. There's a question that's also been asked of our team before, which is, can I transfer information in and out of South Africa? The answer to that question is a bit nuanced. You can only use the personal information for the purposes that you acquired it for, right? So you can transfer information in and outside of South Africa if it is still within the purpose for which you acquired that information. This means that if necessary, you can transfer data that is held on your local servers to foreign servers, provided you're still using that data for the purpose that it was acquired for. Another simple question is, how should organizations obtain consent? I've answered the bulk of that question, that one of the most useful ways to obtain consent is within legal agreements that are signed with your customers. Those legal agreements need to make the consent, need to make whatever authority you would like with regard to personal information clear and not embedded deep within the document in obscure ways that customers, for instance, do not notice it. So you can obtain that consent through signature. Other ways in which you can obtain that consent is by sending your customers a form which they can positively attest to, whether they give their consent or not, provided you've made clear the reasons for which you are acquiring their personal information. A question that we get in terms of the Google Vault product, which deals with email retention, is, how do I use Vault for compliance in South Africa? So Google Vault deals with not only email retention, it also deals with chat retention, it also deals with Google Drive file retention. One of the ways in which you use Vault for compliance purposes is that if you have received a request from a customer or from a third party concerning privacy, and for instance, what personal information you hold on an individual, you can use the search functionality within Vault in order to find the information and put it under legal hold pending further review. A popular question that is asked in business circles and in consumer circles is, does the POPI Act put an end to direct marketing? Can organizations SMS or email somebody or email people to tell them something? POPI does not put an end to direct marketing. What POPI does is that it ensures that direct marketing is conducted in ethical and lawful ways. The simple rule of thumb around direct marketing is that you have to be sure that you acquired the personal information of people through ethical ways, and that the reason you acquired that information was made clear, that it was made clear when that information was being made available by the individual, that information could be used for marketing purposes. There is a question around how, this is a question asked internally by a colleague, how do you prevent someone from downloading or printing a file from Drive? Thank you for that question. It's quite a useful question for me to answer, because it does apply to a managing of personal information. In Google Drive, you can do a thing where you can configure documents, you can configure people with comment or view access, so that they can only view the document online within a browser or on their phone, without the ability to actually download it. In order to do that, when you share a document with that particular person, give them comment or view access and check the option that says prevent download or printing of the document. Okay, there's a question here on what are the benefits of a security key over two-step verification, or should they be used concurrently? So this is more of a security question. The main benefit of the security key is that the security key itself is actually a separate object, and a separate object from something like your cell phone, which may be the target of somebody pinching the phone, because you carry your phone in many visible ways, but the security is something that you can keep quite discreet, and is not very noticeable. So I would rate security keys as being better for protecting your information, versus your cell phone. But provided you keep good control over your cell phone, you're probably in pretty good stead. Okay, I'm just going to check if any other questions have come in. And it appears not. So on this note, then I will conclude the webinar, highlighting that you can get a hold of us via our different points of contact, like sales@opennetworks.com, support@opennetworks.com, or speaking to an account manager. And you can also get a hold of us via our various social media platforms, such as Instagram, Facebook, Twitter, or LinkedIn. I guess that is it from me. Thank you, everybody, for attending the second of our Cloud Safety and Security webinar series. Have a good day.